Hi, I'm John Bursch, Vice President of Appellate Advocacy with Alliance Defending Freedom. Pleased to be speaking with you today for roughly 20 minutes about the legal implications of gender, sexual orientation, and life issues for business, and what degrees of freedom businesses still have. Now, even a cursory check of the news will show that faith-based businesses are increasingly under attack. Some of those cases have been litigated already to the U.S. Supreme Court, most notably the Hobby Lobby case involving the federal contraceptive mandate, and Masterpiece Cake Shop, the case involving the master cake artist Jack Phillips from Colorado. These cases are good illustrations of how the law impacts faith-based businesses with their requirements, but also the freedoms that are available. And so we're going to explore those and many other areas of the law over these next 20 minutes. I'll begin with a discussion of SOGI laws. These are sexual orientation and gender identity laws, SOGI laws, that can be enacted at any level of government. Over the past several decades, many states and some localities have adopted anti-discrimination SOGI laws. They can apply to employment, they can apply to public accommodations, they can apply to housing, all kinds of different areas. But those attempts have generally failed at the federal level. Consider for a moment just federal employment law, that's Title VII, the federal statute that governs the hiring, firing, promotion, hostile work environments, and things for businesses all across the country. Congress has tried to amend Title VII to add sexual orientation more than 50 times, and all those efforts have failed, and has also tried to amend Title VII about a dozen times to add gender identity. And that classification addition attempt has also failed. But all of that was modified somewhat when the U.S. Supreme Court announced its Bostock decision this past June. Now, Bostock involves Title VII, but it's actually three different cases, and understanding those cases helps explain a little bit where the court was headed with this. The first of the trio of cases was a case involving Harris Funeral Homes. And the funeral home, like every funeral home, has professional policies of conduct and dress to ensure that its clients are able to process their grief and stay focused on that, as opposed to focusing on the funeral home and its employees. They had a male funeral director who, for 6 years, had complied with the funeral home's sex-specific dress code. And at the conclusion of those 6 years, gave a letter to the funeral home owner, Tom Rost. That letter stated that the gender identity of the employee was actually female, and that the employee was going to be gone for 2 weeks, and upon returning would be dressing and presenting as a woman when spending time with the funeral home's clients. Well, the funeral home owner thought about this at some length. He considered everything that the employee must be going through, but also thought about other employees, especially female employees who'd be sharing a restroom with this particular employee, and also about how this would impact families and how they process grief when they were at the funeral home. A family that lost their father in January could have come and dealt with a funeral director, Anthony Stevens, and then if they lost their mother in April, would come back and be dealing with Amy Stevens and the impact that would have on those clients. And ultimately, the owner decided that was something he could not go along with. The EEOC filed suit, and they claimed that this was sex discrimination under Title VII. That case was litigated all the way to the U.S. Supreme Court, and we'll get to the result in a moment. The other two cases, Zarda and Bostock, involved claims against a skydiving company and county government, respectively. Each one of those cases involved plaintiffs who claimed that they were being discriminated against based on sexual orientation. Now, in the Bostock case involving the public government employee, it was dismissed at the pleading stage, and so there were no allegations or defenses really from the employer, but they obviously publicly, strenuously denied that they had fired anyone because of their sexual orientation, but claimed that this particular employee had been engaged in financial improprieties. At the skydiving company, they actually went to a trial under a state law claim for sexual orientation discrimination, and a jury concluded that the employee had engaged in misconduct on a skydive with a customer of the opposite sex and had not engaged in sexual orientation discrimination at all. And yet in that posture, all three of these cases made it to the U.S. Supreme Court. Now, the Supreme Court's job was to determine the meaning of discrimination because of sex, which is the operative language under Title VII. What's more, it had to say what the original public meaning of those words were, discrimination because of sex. In other words, they had to look at what the public would have understood the plain language of the statute to mean when Title VII was enacted in 1964. Unfortunately, a Supreme Court majority came up with an interpretation of the statute that no one in 1964 would have understood to be its public meaning. The Supreme Court said that because sexual orientation and gender identity are so closely related to sex, essentially intertwined, that the Title VII statute covers those classifications as well. But there are a couple of caveats here that limit the ruling, which are going to be important as we go through this discussion. First, the court made clear that under federal law, the meaning of sex is still biological sex, something that is objective and determined based on sexual organs or on genetics. And it's not something subjective that can simply be professed. So that was one important aspect of the whole thing. In addition, the court didn't address at all many of the other scenarios that might involve an employee that the employer's decision wasn't based on sexual orientation or gender identity per se. So for example, the court saved for another day whether a company could apply a sex-specific dress code. In the Harris Funeral Home case, then, the primary issue has not been resolved. The court also said that it would not address sex-specific policies involving showers, restrooms, locker rooms, overnight facilities, things of that nature. And finally, the court said that it was not addressing any of the various religious liberty defenses that a business might bring to these types of claims. Specifically, the court called out RFRA, which is the Religious Freedom Restoration Act. That's a federal statute that provides relief from other federal statutes that impinge on religious liberty in the way that it's exercised. And the court even described RFRA as a super statute, which we'll come back to. That's very encouraging. So what the court held very narrowly was that when an employer fires someone or takes some other adverse employment action simply because of someone's sexual orientation or their gender identity, that is something that is barred by Title VII. Again, no one would have understood that as the public meaning of the statute in 1964, but there we are. Title VII has now been expanded, and businesses need to take that expansion seriously. Now, moving over to the life side of the equation, the place where a faith-based business would most frequently run into this is in the area of contraceptive mandates as part of company health plans. Very famously, because of the Hobby Lobby case and the Little Sisters of the Poor, everyone should be familiar with the Affordable Care Act and the regulation that was passed after the statute was passed. Keep in mind, the Affordable Care Act doesn't say anything about contraception. But the Department of Health and Human Services, in deciding what the panoply of things that needed to be covered as part of a mandatory employee health plan should be, included artificial contraception, and that includes abortifacients. And so for a Catholic business, all of these are verboten. That contraceptive mandate is one that appears not only federal law, but in some state laws as well. So for example, Illinois, California, the state of Washington, all have state-level contraceptive mandates that look very similar to the federal mandate, only sometimes they're even worse. Some of those statutes will actually include surgical abortions, and some statutes, California and Washington's, for example, even go so far as to apply their rules to churches. Whereas the federal government's contraceptive mandate, even at the very outset, was never applied to churches themselves. And so immediately now you have the tension between SOGI laws and these mandatory contraceptive and abortifacient laws on the one hand, and individual freedoms for companies and their owners on the other. So let's start to talk about those. Well, with respect to the federal contraceptive mandate in the ACA, the Obamacare mandate, we now have a federal regulatory exception to that. The Department of Health and Human Services in the current administration walked away from the very narrow exemption that had existed in the previous administration that only applied to churches. And it says that any individual or any entity that has a moral or a religious objection to the provision of artificial contraception or abortifacients or abortion services is exempt from that mandate. And there were a couple of states that challenged that rule that went all the way up to the U.S. Supreme Court. And just this past summer in the Little Sisters of the Poor case, not the original Little Sisters of the Poor case, but the most recent Little Sisters of the Poor case, the federal government or the U.S. Supreme Court rejected the rulings of the lower courts that had struck down that regulation. That does not mean the litigation is over. There are still other issues that are being litigated in the lower courts. And of course, if there is a change in administrations, that exemption could be rolled back. At least one presidential candidate has already promised that if he's elected, the first thing that he's going to do on day one is to force the Little Sisters of the Poor to again provide artificial contraception and abortifacients. But at least for the present moment, that's a form of protection that every business has from the federal law. In addition, you have the Religious Freedom Restoration Act, or RFRA, which we discussed. In one of the concurring opinions in the Little Sisters of the Poor case that was decided this summer, the concurring justice explains that under RFRA, this exemption that the federal government created for faith-based businesses was not only reasonable, but it was absolutely required. And if a further or future administration does change the regulation to eliminate or narrow that exemption, you can be confident that that's an issue that will also be litigated to the Supreme Court, with the backdrop that in the Bostick case, the U.S. Supreme Court decided or described that RFRA statute as a super statute, which is something that we can all take some comfort from. That same RFRA statute, incidentally, would also apply in the context of Title VII claims. So if you had an employer who, for religious reasons, did not want to have a company health plan that provided benefits to same-sex partners, for example, if federal law required that, or any other aspect of federal law, even the discrimination prohibitions that come through Title VII as a result of Bostick, RFRA would provide a defense to all of those things. You would have to demonstrate that you had a sincerely held religious belief, and you would have to also demonstrate that the federal law was substantially impeding you from being able to exercise that religious belief. But in many cases, that'll be entirely possible. And in that respect, it'll give you an opportunity to defend yourself. In addition to RFRA, we have broader constitutional rights that exist at the federal level. And unlike RFRA, which would apply only to exempt a business from federal laws, so RFRA might get you out of a federal contraceptive mandate, but it would not get you out of a Washington or a state of California contraceptive mandate. These constitutional principles apply more broadly. So we'll start with the free exercise clause. This is in the First Amendment. It guarantees all of us the free exercise of religion. At its narrowest, one thing that is crystal clear after the Masterpiece Cake Shop case is that the free exercise clause protects faith-based businesses from government actions which are motivated by religious animus. To understand what that means, let's focus just for a couple of minutes about the Masterpiece Cake Shop case itself. As I mentioned, it involved the master baker, Jack Phillips. He had a bakery in Colorado. He served all customers, anyone who came in his store, but there were certain messages that he could not express in the custom-made baked goods that he created. So for example, he was opposed to people drinking alcohol and getting drunk from that. And so he would not make a cake that had an alcohol theme or that had alcohol in it. Because he was concerned that images related to Halloween might cause people to focus on the occult as opposed to God. He would not make any Halloween-themed cakes or other cakes that involved that kind of very negative spiritual theme. He also, because of his Christian beliefs about marriage, could not create a cake that celebrated a union of a same-sex couple. That would be something that would require him to use his creative talents in a way that would violate the core of his religious beliefs. And plus, because he would take those cakes, get them set up at the wedding reception, help cut the cake, and participate in the celebration, it also required him to participate in a celebration that violated his beliefs. Well, there was a customer that came in and requested a cake for a same-sex wedding celebration. Jack respectfully declined, referred them to some other bakers that would do a good job. And as a result of that, Jack was sued by the Colorado Civil Rights Commission under one of these state SOGI laws that prohibits discrimination in business transactions based on sexual orientation. That claim was ultimately resolved in favor of the Civil Rights Commission in the Colorado State Courts and the Colorado Court of Appeals. The Colorado Supreme Court declined to step in, but the U.S. Supreme Court did step in, and they reversed the case. Now, there were lots of claims made in that case based on broader free exercise principles and free speech principles that I'll discuss in a moment. But the court ruled in favor of Jack and his cake business based on the animus principle. There were numerous statements in the record of the Colorado Civil Rights Commission's deliberations about this case that showed that they had it out for someone who had the Christian religion and Christian beliefs about marriage being between one man and one woman. They said that those beliefs were discriminatory. They compared them to Hitler and the Ku Klux Klan and things of that nature. One of the punishments that they prescribed was that Jack and his employees, mostly his family members, would be required to go through remedial training to teach them how their beliefs were wrong and discriminatory and bigoted and things like that. And relying on some fairly well-established principles, cases that the court had previously decided, which said government can never act with animus towards religious organizations or religious businesses or religious individuals, the court said that's enough. And critically, the court said it didn't have to be overwhelming evidence of religious animus. There only had to be a suspicion. If you even thought that there might be religious animus in that process, that's enough to throw out the government action. So taking that principle and moving it forward, to the extent that any business is prosecuted by a state or a local government, or a new law is passed that potentially puts that faith-based business in danger because of their religious beliefs about marriage and about human sexuality, any evidence whatsoever, any suspicion that the government was acting out of ill will because of that religious belief or because of a religion, that's out of bounds. It's unconstitutional, and that's the end of the story right there. Now, we also have some broader free exercise rights. And here it gets a little tricky, and I'm going to discuss briefly two Supreme Court cases that bear on that issue. The way the founders would have understood the free exercise clause, those who drafted and the people who ratified the First Amendment, was that it would prevent the government from substantially interfering in any way in the free exercise of religion. Now, several decades ago, the Supreme Court severely circumscribed that right through a case called Employment Division versus Smith. And in Smith, the court said if you have a facially neutral law, that is, one whose text does not specifically target people of religion or religious faith, and that is a statute that was enacted without religious animus and applied equally to everyone, then you have to comply with it, even if it violates your core religious beliefs. Well, you can instantly see how that can't possibly be right. Just think about the Catholic Church itself. If you have an employment law that requires that men and women are treated equal, and the church declines to hire a woman to be a priest because of its long-held tradition and religious beliefs about only men being priests, that would flunk the Employment Division versus Smith test. Now, we have other carve-outs for that built into the law, but just thinking about the Constitution and the First Amendment, no one at the time that the free exercise clause was written and ratified would have thought that the government could do something like that to the Catholic Church. That would clearly be a violation of its exercise of its religion. But yet we have this case on the books now, which is causing all kinds of trouble. Well, fortunately, in the term that's just beginning, the U.S. Supreme Court is going to be considering a case to overrule Smith. It's called Fulton versus City of Philadelphia. It involves a Catholic adoption agency through Catholic Social Services in Philadelphia that was terminated from providing any adoption or foster care services for the city simply because it declined respectfully to place children with same-sex couples because that violated the Catholic Church's teachings. There had never been a complaint against the agency. A same-sex couple had never even asked for their assistance in getting a child in a foster placement or to place them for adoption. It was simply because the city wanted to punish the church and this adoption agency and their beliefs that they adopted this rule. And one of the questions presented in that case is whether the Supreme Court should re-examine Employment Division versus Smith and overrule it. And if it did, that would restore the vitality of the free exercise clause in a way that would be tremendously helpful to faith-based businesses. Now, in addition to these free exercise principles, we also have free speech principles. That was a claim that was raised in Jack Phillips's case and was not resolved, but it comes up all the time in cases involving businesses that are creative professionals, videographers, calligraphers, artists, speechwriters, publishers, print shops, things of that nature. And the case law in this area looks pretty good. A number of years ago, there was a case involving a business called Elaine Photography. That case is still ongoing, but was not resolved in favor of the photographer. But since then, we have a number of cases, including the Telescope Media Group case out of the Eighth Circuit Court of Appeals, which upheld a videographer's free speech rights to be able to film weddings and wedding receptions without having to violate their beliefs and celebrate same-sex wedding celebrations. We have the Bursch and Nib case out of the Arizona Supreme Court. These are both Alliance Defending Freedom cases that upheld the right of calligraphers and artists to be able to do wedding invitations and table cards and things like that for weddings between one man and one woman, consistent with their Christian beliefs, and not celebrate same-sex wedding ceremonies. And so you can see, I wouldn't call it a tidal wave yet, but certainly a trend of cases upholding businesses' free speech rights in this context. So our time is drawing to a close. So the points that I want to leave you with here are that there are numerous federal, state, statutes, as well as U.S. constitutional principles that will protect you and your business when you encounter a situation where you're being asked to violate your religious rights. To be able to take advantage of those, it's critically important that you have articles and bylaws for your company, as well as employment manuals and other things that make clear that you run your business according to faith-based principles. If you don't have any of those foundation documents and practices and policies in place, and then all of a sudden you go into court and say, well, we're a religiously motivated business, you're going to have a very difficult time proving those claims. If you go to the Alliance Defending Freedom website, which is adflegal.org, you will be able to find resources to help you properly incorporate and put policies in place to make it clear to courts that you are a faith-based business. And we are always happy to take any call if you're put in a situation where a government actor or a law has put you in a situation where you feel you have to violate your Catholic faith. In addition to the principles that we've talked about, there are a number of others that you can bring to bear on these types of cases. But the bottom line is you don't have to give up the principles of your Catholic faith in order to be in business. You still have substantial constitutional and statutory freedoms to exercise your faith, not only in your home, not only in your church, but in your business and in the public square. So be courageous, stay strong in these circumstances, and call us if you ever need help. Thank you very much, and God bless.